Hello everybody, welcome back to the Anarchist audio library. Today we are going to be finishing the piece Resisting Medicine, Re/Modeling Gender, first published 2003, read 2024. Written by Dean Spade, read by Naomi Kirst-Schultz. Part 3. Negotiating a Transgender Praxis. Informed by my own experiences navigating the medical model of transsexuality and those of my friends and clients, my goal for trans law and policy remains demedicalization and an end to practices that coerce people into expressing gender identity through a narrowly defined binary. I would like to see the end of gender designation on government documents, the end of gender segregation of bathroom and locker room facilities, and the end of involuntary, quote, corrective, unquote, surgeries for babies with intersex conditions. I would like people to have the freedom to determine their own gender identity and expression and not be forced to declare such an identity involuntarily or pick between a narrow set of choices. And I would want no person to be required to show medical or psychiatric evidence to document that they are who and what they say they are. I would like self-identification to be the determining factor for a person's membership in a gender category to the extent that knowledge of the person's membership in such a category is necessary. I certainly believe that we can move toward deregulating gender and still engage in important corrective practices like gender-based affirmative action. I am not arguing for a gender-blind society in which all people are similarly androgynous, but instead for a world in which diverse gender expressions and identities occur, but none are punished, and membership in these categories is used less and less to distribute rights and privileges. Similarly, I would want various groups of similarly identified people to be able to seek spaces to meet together and for the inevitable conflicts that emerge regarding the identity borders erected by those groups to be determined by negotiation and cultural work, not by legal or medical determinations of gender category membership. These are my goals for gender and law, but in my work as an advocate for low-income gender-transgressive people, I am often forced to recognize how far we are from attaining these goals. Consequently, I engage in compromises that I hope will be steps toward the deregulation of gender, compromises which provide access to vitally needed services and entitlements for gender-transgressive people who are in crisis now. These compromises, moreover, are necessitated by the fact that most of the successful legal claims for trans equality have come through strategic use of the medical model of transsexuality. The history of legal struggles for trans rights, of course, has been dominated by judicial decisions, which would not recognize gender transition at all and would not allow gender change no matter what medical evidence was presented. Through extensive effort by activists and lawyers, however, an increasing number of legal and policy victories have emerged. Most of these have made trans access to discrimination protection, identity document change, or other legal remedies entirely reliant on documentation of medical procedures, usually genital surgery. The mostly unexplored territory remains in the realm of demedicalization, where trans rights are recognized but will not hinge upon surgical status or medical evidence. As an attorney working to improve the conditions of people living in crisis, I have to accept that my job cannot just be demanding that all laws I am working to reform immediately relinquish any reliance on medical evidence. Instead, I end up doing a lot of work to get things moving in that direction, but often without even the option of invoking where I am headed. A good example is my recent work with the Department of Vital Statistics in New York City. The current vital statistics policy for changing sex designation on birth certificates, derived from the recommendations of a 1965 committee appointed by the New York Board of Health, requires a person to prove that she has undergone genital surgery in order to change her sex designation. Even upon showing of such proof, here designation will only be changed from its current marking to a blank, not to the letter reflecting here new gender identity. The policy creates an enormous barrier for people seeking to change their birth certificate so that they can apply for educational or economic opportunities or prove membership in a gender category for purposes of a sex-segregated facility. I have been working with attorneys, medical and mental health professionals, and civil rights organizations to encourage Vital Statistics to change its policy not only with regard to leaving sex designation blank, which is certainly unusual and uncommon amongst jurisdictions issuing birth certificates, but also with regard to requiring genital surgery as a precursor to sex designation change. We have led this negotiation, of course, with our most conservative and non-threatening arguments. We have argued that many people cannot undergo surgery because of pre-existing medical conditions. Additionally, we have demonstrated that medical treatment and understanding of transsexuality has changed since 1965. The medical emphasis is now on determining a course of treatment appropriate to individual patients rather than on a single surgical procedure as the culmination of all patients' treatment. We have emphasized that 90% of trans men do not seek phalloplasty because an effective procedure has not been developed. We have asked that a new policy more suited to the current state of medical treatment of transsexuality be applied, one in which medical documentation that the transition is complete and all necessary medical procedures have been undergone be accepted as sufficient evidence. This standard, which no doubt will still be difficult for many trans people to meet, would be an enormous improvement for trans people born in New York City. It would also be the best birth certificate policy in the country because it would possess the fewest medical requirements. However, getting a new policy in place requires me to make strong arguments based on the medical governance of transsexuality to the vital statistics staff, who are deeply concerned about people, quote, changing back, unquote, if they lower their requirements. These arguments involve my detailing how wonderfully rigid the medical processes of transition are, and how no one passes through without making a permanent decision to live in their new gender. Of course, I am at the same time continually working to loosen the medical grip on trans people, and to challenge this fear of, quote, changing, unquote. Even as I argue to these policymakers about how legitimate that tight grip is and how they do not need to police trans identity because the doctors will do it for them. This negotiation demonstrates the position that trans attorneys and advocates are placed in when wrestling with the fact that, to some extent, the medicalization of trans identity was at one time a progressive step toward dignity and equality, because it was preferable to total illegitimacy and criminality. However, even as we rely on it to argue that trans people should be protected from discrimination and allowed to legally change our genders, we proceed with caution and work to reduce the gatekeeping powers of medical experts over us. The most pressing and controversial area in trans law bringing up these issues currently is the question of whether and when disability discrimination claims should be used to address instances of gender identity discrimination. In an ideal world, many trans advocates, including myself, would like to see gender identity discrimination dealt with through gender discrimination claims. In my view, gender identity discrimination is fundamentally an aspect of gender discrimination. Sexist oppression requires that all people adhere to two narrowly defined gender categories, that all people work, dress, reproduce, and generally behave according to the standards set out as appropriate for members of their respective categories, and that all people be afforded or denied rights and privileges based on their membership in and performance of these categories. Those who violate these norms by trying to work in a field not designated for their gender, or by refusing to dress according to the expectations of the gender category they have been assigned, need protection from discrimination based on such narrow expectations of how people of each gender should live and behave. Anti-gender-based discrimination law, then, is the logical place to find protection for people being discriminated against for, say, wearing a dress when they are considered, quote, male, unquote, by the discriminator, or requesting to be called by male pronouns when they are considered, quote, female, unquote, by the discriminator. However, as much as I prefer those claims, there are serious obstacles to pursuing gender discrimination claims when seeking trans rights. For one, most courts have found that Title VII does not protect against discrimination for trans people because the statute's intent was solely to eradicate barriers to, quote, women's, unquote, equality. With similar rationales, many state courts have refused to extend protection under state gender discrimination law to trans people. Because gender discrimination claims have often been a dead end or a risky venture, disability discrimination claims have become an important alternative. The federal disability statutes, the American with Disabilities Act and the Rehabilitation Act, both explicitly bar coverage of transsexuals. However, trans plaintiffs have had some success with disability discrimination claims under state disability discrimination statutes. In my own practice, my greatest struggle with the issue of whether to use disability discrimination claims came when I was working with a team of attorneys on the Jean Doe versus Bell case. That case involved a young trans woman in foster care who was moved to a group home facility where she was not allowed to wear skirts or dresses. We sued the Administration for Children's Services seeking a change in policy and brought claims based on gender discrimination, the First Amendment, and disability discrimination. I worked with a team of attorneys from a large firm in addition to 2 attorneys at my hosting agency on the case. I was the only trans person besides the plaintiff involved in the litigation. I was also the youngest attorney and the person who had been practicing for the shortest amount of time. My colleagues wanted to pursue the most winnable claims in the most direct ways possible. Even with my continued discussion of the controversial nature of disability law claims for trans plaintiffs, they generally seemed unconcerned about the broader implications of relying on GID in our lawsuit. I was deeply concerned about the disability discrimination claim for a number of reasons. First, claiming disability discrimination required pleading, quote, a physical, mental, or medical impairment resulting from anatomical, physiological, genetic, or neurological condition which prevents the exercise of a normal bodily function or is demonstrable by medically accepted clinical or laboratory diagnostic techniques, unquote. I was concerned about relying on GID to meet this requirement, both because of my misgivings about the description and treatment of that diagnosis, and because I knew that many trans youth in foster care will never be able to access such a diagnosis because they lack access to any medical care, let alone care that is trans-friendly. As I worked with the other attorneys on the case, I continually ran up against their lesser interest in thinking about the broader implications of the case for other trans youth, and their narrow focus on winning the single case for the single plaintiff. There were some aspects of our New York disability claim that eased my misgivings a little. The positive aspect of the, quote, impairment, unquote, requirement was that, unlike the federal disability statutes and some state statutes, we did not need to plead that Jean was, quote, substantially limited in a major life activity, unquote. New York's disability discrimination coverage is broader, allowing individuals with diagnosable impairments, even if they cannot prove limitation in a specific major life activity, to be considered, quote, disabled, unquote, for purposes of the statute. This meant simply demonstrating that Jean had been diagnosed with GID was enough to get her covered under the law and to force the court to look at whether she was being discriminated against by the dress code policy. Nonetheless, I was very concerned about relying on GID in our claim. We won the case, and the court chose disability discrimination as the claim upon which we would prevail. The court's decision establishes a basis for challenging discriminatory treatment of trans youth in foster care in New York, a pervasive problem, and also strengthens claims about discrimination against trans people in other contexts. However, its reliance on disability law claims highlights some important questions in the trans community. The first response that always comes up, which does not get to the heart of my concerns about these claims, is the argument that trans people do not want to be seen as, quote, disabled, unquote. There's a gut reaction that occurs where people feel that using disability law claims means we are arguing that we are somehow flawed people. What is at play in this response is ableism. And this reaction is usually resolved by pointing out that the theory of disability law is not about going into court and arguing for rights, based on an idea that people with disabilities are flawed. Instead, the disability rights movement and the legal claims developed by the tireless activism of people in that movement is about pointing out that disabled people are capable of equal participation, but are currently barred from participating equally by artificial conditions that privilege one type of body or mind and exclude others. Similarly, trans people could use the disability rights framework to argue that we are fully capable of participating equally, but for artificial conditions that bar our participation. Examples of such conditions include gender-segregated facilities or dress codes administered according to birth gender. Like others in the disability rights movement, trans people are fighting against entrenched notions about what, quote, normal, unquote, and, quote, healthy, unquote, minds and bodies are, and fighting to become equal participants with equal access and equal protection from bias and discrimination. This part of the overlap between disability rights and trans rights is not what concerns me. What does concern me is the process I have to go through to plead a disability discrimination claim for a trans plaintiff. Specifically, if I have to find a, quote, diagnosable condition, unquote, I have to rely on GID to make my claims. I do not want to make trans rights dependent upon GID diagnoses because such diagnoses are not accessible to many low-income people. Because I believe that the diagnostic and treatment processes for GID are regulatory and promote a regime of coercive binary gender, and because I believe that GID is still being misused by some mental health practitioners as a basis for involuntary psychiatric treatment for gender transgressive people. I do not want to legitimize those practices through my reliance on the medical approach to gender nonconformity. One part of me believes that real harm will not come from using disability discrimination claims. I understand many attorneys' argument that we have an ethical obligation to our clients to plead all winnable claims. Additionally, because we can plead multiple claims and judges can pick and choose on what basis to rule, perhaps it is best to plead all possible bases for victory. However, another part of me recognizes the ease with which non-trans people might approach a medicalized and pathologizing approach to gender difference, and that this may cause judges to continually choose disability law claims and thus ignore more appropriate claims of gender discrimination. Consequently, I use these claims with extreme caution. We must strike a balance between wanting to avoid over-reliance on medical evidence while contending with the fact that many trans people's lives are entangled with medical establishments, and for those people it would be beneficial to prove that sex reassignment-related treatments are, quote, medically necessary, unquote, and should be covered by Medicaid and private health insurance. Attorneys and advocates working for trans equality have to skate this delicate line, demedicalizing legal approaches to gender identity where we can, educating medical providers on how to provide medical services to gender transgressive people in ways that respect and encourage individual expression rather than conformity to binary gender, and also fighting for increased access to medical care for all people. Moreover, because of the compromised and potentially dangerous character of successful litigation on behalf of trans clients, our advocacy must also address the systemic problems inherent in the institutions that entangle our disproportionately low-income clients. In my work, in particular, I understand that the institutions which dominate my clients' lives, prisons, foster care, public benefits programs, juvenile justice, and the like, are often mobilized to do harm by racist and anti-poor sentiment. These same institutions, more often than not, are gender-segregated and operated through violence, harassment, and intimidation that particularly impacts people whose bodies and expressions violate binary gender norms. The more I work in law, the more invested I become in the non-legal activism I engage in, because I realize increasingly that the role of law in creating the fundamental shifts that we are demanding is limited. I am excited about using legal skills to help trans people in crisis and engaging in creative use of medical evidence when necessary to assist my clients, but I also recognize that legal cases are always about single plaintiffs or classes of similarly situated plaintiffs and cannot always do the work necessary to create remedies and protections for the diversity of gender-different people. Sometimes it is possible to use victories for single plaintiffs to expand rights for a broader group, but it is always important to be careful that the fight for a single plaintiff's rights does not curtail rights for a broader group. For example, I do not want to plead cases for clients who have undergone medical procedures in ways that will lead to a victory where the rights of trans people hinge on undergoing those procedures. For this reason, I think it is important that trans people be a part of conversations about how legal claims are pursued by attorneys, and that attorneys working on such claims understand themselves to be determining not just the rights of a single plaintiff, but impacting a broad set of gender transgressive people who may differ from the plaintiff in question in essential ways. Additionally, I think that now, more than ever, trans activists should be thinking about how we can work in coalition with other activists, particularly those working to combat racism and end poverty, to increase awareness of what role trans and gender transgressive people have in anti-racist and anti-poverty movements. Trans people remain disproportionately low income, struggling against gender segregation in regulatory government facilities and services where we are still usually placed based on genital status. As we struggle with medicalization in these contexts, we have valuable opportunities to ally ourselves with other communities that are fighting against the violence and dehumanization of these systems, Too often, legal rights organizations in the LGB movement have been focused on gains that predominantly benefit upper-class people and have failed to prioritize welfare rights, affordable housing, police brutality, and other policy areas central to the lives of low-income people and people of color. Trans people have also been marginalized by this mainstream movement and our issues ignored or put on the back burner. As we emerge, struggling for our own equality and demanding accountability from community organizations that have failed to include us in their struggles, we must keep our attention on this history of racism and classism in the LGBT movement and discover new ways to ally ourselves with movements that are addressing the institutions in which we too remain entangled. In this way, the negotiation of medical knowledge in trans people's personal and legal struggles makes clear that a multi-strategy approach is always necessary for political action. Legal reform will not be the forefront of bringing the fundamental changes to gender oppression that I desire. I believe in the necessity of litigation and policy work to alleviate immediate crises in the lives of trans people, but I also know that organizing and cultural work have been central to this movement since its inception. Even if we see increasing legal victories, we need to remember that it is that work which will lead to the kinds of change we want to see. Change unmitigated by entanglement with the regulatory medical constructs that we are striving to escape. This has been Resisting Medicine, Re/Modeling Gender, written by Dean Spade, read by Naomi Kirst-Schultz.